God save these United States, great state of Florida, and this honorable court. Ladies and gentlemen, the Supreme Court of Florida, please be seated.
Good morning. Welcome to this session of the Florida Supreme Court. The first case on our docket is in re amendments to the Florida Rules of Civil Procedure, etc. A lot of procedural rules are in this rules case. And before we get started, and I recognize Judge Munyon, I want to thank everyone who has participated in submitting comments for this rules case. I also want to thank the work group that put together the package and responded to the comments, and I particularly thank Judge Munyon for her leadership. This is it's a complicated subject, and it's an important subject. I would ask, as we go through this, that we've got an hour. If we need a little more, we'll take a little more. But that everyone try to focus on kind of the most recent version of what we're talking about here, which are is the version that the work group has come back with in response to comments. Because I think some of the concerns have been addressed in that. And of course, you can say whatever you want to and focus on whatever you want to, but I think it would be more productive use of time to focus on that rather than kind of his history of how it developed, except to the extent that that is relevant to some remaining concern you have. But with that, I want to recognize Judge Munyon.
Thank you, if it please the court. Chief Justice Kennedy, Justices, good morning. Thank you for the opportunity to address you this morning. My co-petitioner and I would request 8 minutes in rebuttal. I will take 10 minutes of the petitioner's time in this initial argument, and Judge Orfinger will take 5. Because of the limited time and the many areas covered by this rule, if it please the court, I will begin with a very brief overview of how the work group structured the proposed rules. I will then concentrate on areas that seem to be most in controversy. The petition spans 7 rule sets and 26 rules. Many are technical or conforming changes because of the change in terminology, but there are substantive changes in these rules. In proposing changes to the rules of general practice and judicial administration, we strive to keep this rule set as rules of general application. If particular case types needed exemptions from the general rules and the RGPJA, we encourage those exemptions or exceptions to be codified in the applicable rule sets. We considered the comments very carefully and tried to make adjustments to the proposals to address the concerns expressed where we could do so and maintain the fidelity of the rules that we were proposing. I will be the first to acknowledge that these rules aren't perfect. The work group did the best it could with this complicated subject. And I would like to thank State Court Administrator Allie Sackett and the Office of State Court Administration for all of their hard work in assisting the work group in coming up with the petition and these rule changes. The first area of controversy deals with how these rules impact self-represented litigants. The work group recommended that Rule 2.516 B1C and D be amended to require self-represented litigants to designate a primary email address for service by electronic mail unless the SRL declares under penalty of perjury that they're in custody, do not have an email account, or do not have regular access to the internet. 3 forms were created. One form to request to be excused from email service that provides for the clerk to ministerially determine if the SRL has filled out the form correctly and is therefore excused from email service. And the form also provides for judicial review if the self-represented litigant disagrees with the clerk's determination. One of the forms is to designate the email address, and one form for changing a physical or an email address. Opposition has been raised by groups representing self-represented litigants. They argue that the proposals would violate an SRL's right to access to the courts, place SRLs without regular access to the internet at a disadvantage to those with immediate access, that e-service should be opt-in, not opt-out, and will expose self-represented litigants and lawyers to greater cybersecurity risks, will increase defaults and dismissals, will delegate judicial duties to the clerk. The work group made changes and provided forms based on their feedback. However, the work group does disagree with many of the comments on this issue. Because a straightforward process is provided for self-represented litigants to request to be excused from email service, there is no access.
Judge Manning, could I ask a quick question?
Yes.
Based on your long and exceptional service on the Florida Courts Technology Commission, where you and the other group of folks that serve faithfully there look at the security of our records and our systems, do you think that there is a legitimate concern about security from this?
There is not a legitimate concern about security.
Thank you.
The e-portal recently passed its 10th anniversary. There are more than 350,000 accounts at the portal, and of those, more than 243,000 accounts are self-represented litigants. If there were security concerns, we would know it by now. It would have shown up in the last 10 years. I will tell you that while email service as proposed does not place self-represented litigants without regular access to the internet at a disadvantage over their present status quo, SRLs who do not have email service are presently at a disadvantage to other litigants on the same case who receive e-service. Many times the self-represented litigants don't get e-service, not because they don't have access to an email address or the internet, but because they lack the knowledge about how to sign up for an account at the e-portal. This proposal goes a long way toward leveling that playing field. So I would encourage the court, if you see fit, to require SRLs to provide an email address or fill out one of the forms indicating why they could not provide an email address. It will assist them in getting court documents much more quickly and will not require them at this stage to e-file through the portal. One of the other rules that affects self-represented litigants is Rule 2.530. We have recommended that that rule be amended to allow virtual, non-evidentiary, and evidentiary hearings, even over the objection of a party. Right now, Rule 2.530 requires testimony that is taken via electronic communication to be only permitted upon stipulation by both parties. The self-represented litigant community has argued that if a self-represented litigant does not have regular access to the internet, they should be per se excused, or it should be per se good cause for not having a virtual hearing in a case, whether it be non-evidentiary or evidentiary. I believe this would be short-sighted. Right now, many courts, as this court is doing today, have hybrid hearings. And if a self-represented litigant doesn't have regular email access and wants to go to court, an objection by them, if the proposal is accepted that has been advanced by the self-represented litigant community, if that proposal is accepted, hybrid hearings would be a thing of the past. If one person objects, then everybody has to come to court. Well, if a self-represented litigant in a hybrid hearing wants to come to court and hear what's going on and be there in person, that's great. But it should not stop others who can effectively participate virtually from participating virtually. I would also let the court know, as I'm sure you already know, many courts, we've had to be very creative during the pandemic. And many courts have set up kiosks when we could not have essential hearings in person to allow those without internet access or without equipment or without the skills to participate in non-essential proceedings virtually by coming to the courthouse and being in a safe room by themselves where they can participate via electronic equipment.
May I ask you one
Absolutely.
question? A few years back, in Doe v. State, I think it was 2017, we dealt with Baker Act proceedings.
I was going to get to that one.
And you were?
I
You want me
couldn't get to Doe. That is the
Well-
big controversy as well, I
Well,
think.
why don't I do this? Why don't I just let you follow your script, and when we get to it, we'll talk about it.
All right. Well, that was actually, I was finished with that part, and I will turn to Doe.
Judge Mannion, before you leave,
Yes.
can I just have some technical questions about 2.530 that don't really address the pro se or self-represented parties, but is it kind of the understanding that a party would be required to file a motion for virtual hearing? Let's say we have two attorneys, so we'll go there. Two attorneys for every single hearing that they wanted virtual, or would this be something that would be filed at the beginning and apply throughout the case?
I don't know if we considered that, quite frankly. I think the rule as proposed envisions that the motion or notice of hearing indicate that it is in fact virtual. That would give a party the right to object to that particular hearing being virtual, but it is quite frankly something that I don't recall being discussed.
And then is this something that, let's say, you have, it just seems, was there any talk that based on the past 2 years, that when you had two represented parties, again, two attorneys, not dealing with the self-represented, which is a whole nother issue, that the automatic would be virtual, and then that there would be an opt-out on good cause? It just seems like in this, based on how many, we got a lot of case management things happening now, we have a lot of motions, we have a lot of motion practice. If for every single one, this is an attorney has to file something, let's say they're working with difficult co-counsel who wants to object every time. Does this mean the court has to have a hearing each time just on the request for virtual? Would this be something decided in chambers? I mean, was any of that kind of part of the discussion of what that would play out like between attorneys on that issue?
The presumption under the proposed rules is that if the hearing is 30 minutes or less and non-evidentiary, that virtual would be permitted. Other questions before I move to Baker Acts and Doe? In the petition, the work group did ask the court to revisit Doe versus State as part of implementing the changes to Rule 2.530. I can tell you it gives me a bit of angst to be up here asking the court to revisit something like that in a rules petition. However, Bakers and Marchmans do not have their own rule set. We did not carve out an exception in Rule 2.530 to Baker and Marchman Act proceedings, and we wanted the court to be aware of that. I believe that there are good reasons for the court to revisit Baker and Doe versus State and the physical presence of the judge and Baker and Marchman Act hearings. I will tell you that the facts in Doe are pretty brief, and so it is difficult to glean exactly what happened in Doe, but it appears that the judge and magistrate in Doe that were hearing cases in one county in the southwest part of the state sent an email to all participants with very short notice that all hearings would be virtual from now on. All of the participants would be at the facility and the judge would be elsewhere. There was no opportunity to be heard, no provision for objecting to the judge's decision that the hearings would be virtual. And so writs were filed, I believe, in the second DCA and eventually made it up to this court, in which the respondents argued that they had a substantive right to have the judge present in court with them. Much of Doe relies upon a 1999 report that came out of a work group that was part of the Commission on Fairness that was instituted by this court. Many of those recommendations in that 1999 report have never been realized. And a lot has happened in the technology arena over the past 23 years. So that technology now is very different than technology was in 1999. The accessibility to technology now is very different. There have been many technical advances that permit hybrid hearings. Now, I will tell the court, I'm trying to keep track of my time, that I only have 10 minutes. Many technical...
You've got about 6 minutes remaining.
Oh, okay.
You're actually, I think, moving into your rebuttal at this point. So.
Oh, I am moving into my rebuttal.
Yeah.
All right.
I mean, you're well into it, actually.
All right. Then I am going to stop here and answer any questions you have. And Justice LaVarga, did you have any questions?
So when we considered Doe, that was back in 2017, long before this pandemic came around, and we started using Zoom and all these technology, and things seem to be a lot better now. Like you said, technology has come a long way, and I'm just wondering if your comfort level is there with dealing with declaring somebody, Baker acting somebody through a television set.
It will depend upon the facility and the technology available at the facility. If the facility has a laptop that they pass around from one person to the next, would I feel comfortable with that? No. But if it is a courtroom type setting where I could see everyone can see everyone else, then it might be acceptable. But I think we have to take it slowly, and it has to be on a facility by facility basis.
Would it have to be something that substantial? That pointing to the
Would I
screen?
like that?
Yeah.
I would absolutely like that. Would it be required? Maybe not. But I believe these rules provide a very robust framework for making a decision about whether a virtual appearance is in the interest of justice.
Thank you.
Thank you.
May it please the court. Chief Justice Kennedy, your honors. I'm Michael Orfinger. I'm the chair of the Alternative Dispute Resolution Rules and Policy Committee, and I'm here this morning to speak in favor of the work group's proposed amendments to Florida Rules of Civil Procedure 1.700, 720, 750, 730, if I forgot that one, and Rule of 1.830, as well as Rules of Appellate Procedure 9.700, 720, and 740. They all deal with the use of communication technology in mediation and arbitration at the trial and the appellate level, and the amendments use the proposed definition of communication technology in the proposed amendment to Rule of General Practice and Judicial Administration 2.530. Some of the proposed amendments were not changed in the response, so you can find the original version in Appendix A to the original petition, and the ones that were revised are, in response to comments, are at pages 1 through 13 of Exhibit A, or Appendix A, to the work group's response. To a large extent, the revised rules are intended to memorialize what's been happening in ADR during the pandemic, with necessity being the mother of invention. As a general matter, the amendments are intended to allow virtual ADR to continue beyond the pandemic and to give the parties the maximum flexibility to decide that initial process issue, that initial shape of the table issue of whether mediation or voluntary binding arbitration will be conducted in person or via communication technology, or as we are doing today, with a combination of the two. The two key rules would be Rule 1.700A and Rule 9.700B. The first deals with circuit and county court mediation and arbitration, the second with appellate mediation. And both of those rules make appearance in person the default, unless the parties stipulate to use remote technology or a combination, or unless the court orders, even over party objection, that the proceedings be conducted with communication technology or in that hybrid combination. Now, the rules are structured so that the court can retain control over the method of appearance if it chooses to do so. There may be difficult clients, and the trial court has experienced prior proceedings and sees that, hey, they need to be together. They need to be in person. They need to experience the discomfort of an in-person dispute, just like they would experience the discomfort of a trial. There may be safety concerns which warrant remote appearance in ADR. But it also recognizes, or both of these rules recognize, that ADR is going to be less formal than a trial, less formal than an appearance before a court of appeal, and that there's a benefit to giving the parties control over the process. And I think that's especially true in mediation, because if they can control the process, since they also control the outcome, they're more likely to be willing to settle. And there's some at least anecdotal evidence in from the Civil Procedure Committee in the survey that the ADR Committee section of the bar in the survey that they conducted, and that's in their response. There's also a somewhat similar provision in Rule 1.830A2 for voluntary binding arbitration, which would allow the parties to decide on the procedures to be used, including whether communication technology would be used. And if the parties don't reach an agreement one way or the other, then the referring court establishes those procedures. Also, rules.
I did not warn Judge Munyon that she moved into her rebuttal, but I will warn you, you're now into your rebuttal time.
And she speaks more quickly than I do, so unless you have any questions about what I've covered thus far, I will reserve my remaining time. Thank you, Your Honors.
Thank you.
May it please the Court, Chief Justice Kennedy and Justices, my name is Sandy Solomon. I have the honor of being the chair of the Rules of General Practice and Judicial Administration Committee. We stand here in support of Judge Munyon's work group virtually on all of the issues. As Justice Kennedy pointed out, revision in November adopts many of the changes that we had suggested. We've been working on this rule for about 3.5 years, this rule being 2.530 in particular. It is complex, and the question that Justice Groshans, if I pronounced it correctly, has raised was a matter of debate in our committee at great length, and it really boils down to whether or not the issue is to be presented by motion or by informal request. And there was a split among the committee. We decided that by a slim majority, that the determination of how a non-evidentiary proceeding and an evidentiary proceeding would be handled would be addressed by a motion with a formal objection procedure. In Justice Munyon's explanation of that as to why the objection procedure was necessary was to assist people who were SRLs or otherwise had difficulty in accessing the system. And we adopted that by a majority, but there was still this undercurrent of how many times do you have to ask the trial judge what constitutes an emergency, which division of the court are you in, whether it's a family law case that has emergency motions filed by the bucket load every day that some duty judge has to address, and that's a very difficult process. So we thought that the balance between the motion process and the discretion afforded to the judge or to the court official was sufficient to dilute any inconvenience that was associated with that. But it is an issue, and it is an issue that we thought should be addressed in gradations, but that was basically rejected because of the SRL issue and because of the need for a formal objection. Let me digress. I wanted to address that issue first off because I think that was one of the key issues that we confronted and on which we had a substantial divergence of opinion. But we have been working, and I presented to this court about 5 years ago a set of rules that would have allowed the rules of general practice and judicial administration to be dubbed the rules of general and common application, and to be broadened across all of the rule sets. We have not 7 rule sets, we really have 11 rule sets, and all of them have commonalities because they all go to the courthouse and they all have judges or court officials attending to them. We had such pushback from the various rules committees thinking that who died and left the rules of general practice the boss. After everything was done. And what we did was we provided for a carve-out. And each of the rules that we have provided says something to the effect of, unless governed by another rule set. And Judge Munyon's description of why we don't need a double carve-out for criminal or a double carve-out for juvenile or a double carve-out for civil commitment convinced us that that was the way to go. We have the structure of the rule substantially changed between the original presentation and the time that Judge Munlin's committee or work group came up with their November response or retort. And that restructuring we would like to take a little credit for because we thought that that was the better way to go, to divide it into non-evidentiary proceedings and evidentiary proceedings. We had a debate. One of the other issues that we considered was whether or not there should be virtual participation in voir dire. And the majority of the committee thought that of the 3 phases in which the criminal court, for example, would operate, the qualification of the jurors, the voir dire, and then the trial itself. And some of our members had a concern about whether or not it made sense to exclude voir dire if we were going to include the trial presentation. But there was such a hue and cry and a very vocal group among our members that said that voir dire should not be included, that the lawyers should have an opportunity to question the prospective jurors live and in person The work group adopted or accepted our recommendation in that regard, but it again was a close call that we had as to whether there was a justification for the administrative excusal not being limited to in-person and the trial presentation not being limited to in-person, but somehow the voir dire, the middle piece of it, had to be limited to in-person. We
Counsel, I'm going to let you keep going, but you are about 2 minutes over.
I apologize. I wanted to make sure that
But take a little more time. I just wanted you to be aware there is a clock there. So.
Thank you. Thank you. We agreed with virtually all of the other comments and questions and that the court, that the work group had, and I think I'm finished. I think that unless the court has some questions, we took great pains to address this matter, and it appears that the work group actually started with some of our work product, and we're proud of that, and we thank the court and thank the work group.
Thank you. Now we go to those who are participating virtually. Mr. Stearns.
Thank you. Good morning, Chief Justice Kennedy, and may it please the court. My name is Jason Stearns, and I'm here on behalf of the Civil Procedure Rules Committee as the chair. I want to echo the comments of Mr. Solomon. Judge Munyon and her group did a remarkable job with the task that they had before them. We submitted some comments, and the majority of our comments were incorporated by the work group in its final report. There's one rule that remains, and I'm here to discuss just that one rule. That's 1.430D. This is the rule requiring or permitting participation by jurors in the voir dire process and the trial process. And the issue that the Civil Procedure Rules Committee has, the specific issue, is the timing component. The current work group proposal, and this is at page 39 of the Appendix A, requires that the written stipulation of the parties and motion be filed within 60 days of a jury trial demand.
Counsel, excuse me for a second. We need to try to get the volume up on this if we can.
I can speak up, Chief Justice, if you like.
Well,
Is this better?
I don't know that that's going to do it. I think the problem is here. It's not with you, and it may be.
Is this any better, Chief Justice?
No. But it's not. Again, it's not your problem. We're going to try. To address it. Bear with us just a couple of seconds, and it may be that this is the first time we've done a hybrid proceeding, so we are.
Let me know when I should proceed, Chief Justice Kennedy. I'm not sure.
Not right now. I'll let you know.
Thank you.
Well, if the volume is turned up all the way, then the volume is turned up all the way. So I think we'll just have to proceed and. Okay, let's go. Go ahead, counsel.
Thank you, Chief Justice. As I was saying, the issue that Civil Rules has with the current proposal is the time requirement. 60 days after a jury trial demand is within the first 3 months of the litigation. And our proposal is to leave the timing to the discretion of the courts to remove the very last sentence of 1.430D. The penultimate sentence of that section requires both a stipulation and authorization by the court.
Could you repeat that? Could you repeat that again, please? Could you repeat that, what you just said?
Yes, Your Honor. The second to last sentence, 1.430D, requires the motion and authorization by the court. And so the concerns of the work group, logistics of remote proceedings, getting things set up, and the timing can be handled on a case-by-case basis within the trial court's discretion. So we would recommend removing and striking the last sentence of 1.430D as proposed by the work group. And unless there are other questions by the court, that is all I have to say today. Thank you for your time.
Thank you, counsel. I'm sorry for the interruption. Ms. Rowe,
Good morning. Are you able to hear me okay?
we hear you very well.
Excellent. I made sure my microphone was turned up all the way. May it please the court, my name is Laura Rowe, and I'm here on behalf of the Appellate Court Rules Committee of the Florida Bar. The committee agrees with the work group, like many other participants here today, on most of their proposed amendments to the appellate rules, especially those governing mediation. I'm here today to address Rule 9.320, which governs oral argument. The committee and the work group both agree that the rule should be amended to incorporate the definitions of communications technology as it's included in Ultimate Rule 2.530 as adopted by the court, and to provide that when such technology is used, the appellate courts should make argument available by live broadcast and by posting the recording to the court's website. The primary difference between the continuity work group's current proposed amendments and the committee's proposed amendments is the inclusion of specifics regarding motions practice before the court. In particular, the work group's proposal to include a subdivision E2, which sets forth a procedure for requesting the use of communications technology, subdivision E3, which states that a court has the authority to grant or deny a party's request made under E2, or that it may order the use of communications technology on its own motion. And then subdivision E5, which provides a list of options the court may employ to address a technological malfunction should one occur. Because appellate courts already possess the discretion over the details of conducting oral argument and have successfully disseminated and employed their own practice preferences and procedures over the last 2 years, the proposed language is both unnecessary in order to allow remote oral arguments to continue, and it may have the unintended consequence of creating a procedural bar or otherwise limiting appellate courts in responding to new or developing technical challenges as they arise. A majority of the committee believes that amendment.
Counsel, I'm not following the procedural bar point. What would be the procedural bar?
Sure.
Bar to what?
A majority of the committee shared a concern that too much detail regarding the motions practice before the court and the options available to address technological malfunctions, especially, might create a procedural bar to certain modification of remote appearances that may be necessary and agreeable to the parties, depending on the circumstance. I, for one, am aware of no other appellate rule that provides the level of detail regarding motions practice as that currently proposed by the work group. Rules governing appellate motions do not contain separate provisions stating that the court has the discretion to grant or deny them, for example, or that describe what action the court might take to address an issue or a technological malfunction after the court issues such a ruling. And for example, hopefully this will help, the current proposal from the work group provides that parties might make a request for a remote appearance in their request for oral argument made under subdivision A of the current rule. This is actually inconsistent with current practice. Most Florida courts, including this court, permit parties to seek remote appearance by motion after filing a request for oral argument with the court. And this flexibility, our committee believes, is consistent with the use of remote oral argument to accommodate the needs of both the court, the parties, and the parties' counsel. Furthermore, the continuity work group subsection on technological malfunctions as proposed limits the court to either recess of the proceedings, granting additional time for argument, or dispensing with argument altogether. However, depending on the nature of the malfunction, the parties may wish instead to proceed with oral argument in spite of the issue, or the court's IT staff may nevertheless be able to accommodate the parties through a reasonable modification of the proceedings, as we just saw here today during this argument. So without the addition of this overly specific language, courts retain the discretion to modify argument based on the malfunction or based on the individual circumstances of the parties. And at this early stage in remote appellate arguments, courts should retain the discretion and flexibility necessary to address any problem that may arise during argument. Does that answer your question, Justice?
Thank you.
Thank you. So a majority of the committee believes that no rule amendment is currently necessary to permit appellate courts to continue using communications technology. Appellate courts already possess the discretion to allow for remote appearances at oral argument and have been competently disposing of oral argument, as I stated earlier, over the last 2 years while dealing with the ongoing pandemic and while applying this court's administrative order, SC21-990. Consistent with the observations of several other commenters, including the Florida Bar's Board of Governors, the committee believes that judges are in the best position to balance the interests of the parties and the interests of justice in setting remote appearances, both at trial and the appellate levels. We agree with the continuity work group that communications technology should become a permanent fixture of appellate practice. However, any amendment to Rule 9.320 regarding appellate oral argument should preserve the discretion of the judicial panel and the court to ensure that oral argument is set and conducted with these interests in mind. At this time, a majority of the committee believes that it is still premature to impose rule-based uniformity on the practices and preferences of Florida's appellate courts, especially given the wide variety of developing circumstances to which they must respond in setting and administering the details of oral argument and remote oral argument. Thank you, Your Honors. If no one has any questions, thank you very much.
Thank you. Mr. Musto.
Thank you, Mr. Chief Justice, and may it please the court, Anthony Musto, on behalf of the Florida Civil Legal Aid Association, which is a group made up of the executive directors of each of the major legal aid providers in this state. Initially, I'd like to thank the court for allowing me to appear virtually. That was very important to me, and it is much appreciated. As far as the proposal that is before the court, it is a good one. We support it in principle. It will help our lawyers just as it will help other lawyers throughout the state and judges throughout the state. We do have some concerns, however, about the impact of the proposal on pro se litigants. And we suggest in our pleading several tweaks to the proposal that we believe will address these concerns. Your Honors, those of us who are on one side of the digital divide, the side where internet is inextricably woven into the fabrics of our lives, can very easily lose sight of the fact that there are millions of people from which our pro se litigants are mostly drawn on the other side of the divide. People who face significant hurdles in their lives because of their lack of access to the internet. And the biggest hurdle that is presented by the proposal that is before you is the requirement that these individuals file a form in order to opt out of e-service. This proposal creates a catch-22 for these litigants, because the only ones who are going to want to opt out are the ones who don't have internet access. But how do you get the form? You go to the court's website. If they don't have internet access, they can't go there to get the form. Yes, they can go to the courthouse, but that imposes a burden of time, expense, and trouble for these individuals. The goal of the form, which is to obtain the information necessary to know whether e-service will work, can be met in a much simpler manner. It is the manner that we suggest in our reply. We suggest that the same information can be obtained without imposing this burden on the pro se litigants by simply amending Rule 2.515B, which deals with the information that litigants, self-represented litigants, are required to put in their pleadings. They have to put their name, their address, and their phone number. That's fine. If we add to that a requirement that if they have an email address and internet access, they must include that email address, Then the information that is taken up, as required by the form, is going to be provided to everybody. If there's an address there, they can be served by e-service the same as a lawyer. If there's not one there, then everybody knows that it has to be done through more traditional means. We do not suggest reject the form totally. It will be helpful in situations where circumstances change. They may have email access at the beginning and then lose it due to financial setbacks, and they may need to file something. But we do suggest that the form, whatever its breadth, whether it is the narrow one I suggest or the broader one suggested by the committee, whatever it is, the rules should be changed to say that it is the form or an equivalent pleading containing the information, which would get rid of the catch-22 and the trip to the court. In my remaining seconds, I'm just going to touch on two of the other suggestions we make relating to Rule 2.530, objection to a hearing being held online. It says, as written, that an objection must be made within 10 days. It doesn't say whether it needs to be filed or served within 10 days. We suggest that it should say served, with today's mail service being so spotty, and the fact that the order will inherently be will be sent by mail, and the objection will be sent by mail. Even the 10 days, even with the 5 days for mailing, there's going to be a lot of times where it will be very difficult to comply. Final point I will make today is that in ruling on these objections, the term good cause is shown. While we cannot have an exact definition of good cause, we do suggest that lack of access to the internet should be considered inherently good cause, and that should be put into the rules. With these changes and the others that we mentioned in our pleadings, we feel that this will be a much fairer process for both pro se litigants and a better process for the judicial system. Thank you so much, Your Honors.
Thank you, Mr. Musto.
May it please the court, my name is Nia Tell, former chair of the Alternative Dispute Resolution section of the Florida Bar. Chief Justice, are you able to hear me?
I am.
Thank you. And thank you for allowing me to appear virtually. Our section wholeheartedly supports the continued use of communication technology in court-connected mediations and arbitrations. However, I am going to discuss 3 proposed rule changes. 1, appearance rules for mediation and court-connected arbitration, which set personal appearance as a default and which need further clarification. 2, adding language to the appearance rules to allow parties to change the manner of attendance at the actual mediation or arbitration hearing. 3, revising the notice language in Rule 1.700A2. As to the manner of attendance, our survey results do not support a default or preference for in-person appearance. Absent agreement by the participants, the court should hold a hearing and determine what is the manner by which parties and the mediator will best be able to participate in the mediation process. We advocate for fairness and equal access to justice being the primary considerations given the facts in each individual case. Mediation appearance rules 1.700, 1.720, 1.750E, and 9.700, and the proposed family law rule 12.740D as proposed are not consistent and are unclear. For example, we request Rule 1.700 be clarified so that it is clear that it relates solely to mandatory non-binding arbitration and not voluntary binding arbitration, which cannot be ordered by the court. The rule should also make it absolutely clear that the written stipulations to mediation must be filed in the court file. This is important because parties and the mediator need to know if by signing a written agreement or stipulation to mediation that's not filed, whether they will fall within the scope of the 1.700 rules, which traditionally do not apply to them. So that word written stipulation should be in throughout Rule 1.700 that's filed with the court. That should be clear. Rule 1.700 should include a provision that at the time of the conference or hearing, quote, subject to agreement of the parties during the process, the parties and the neutral may agree to a change in communication technology as the need may arise to assure equal access to the process. This language in our comment will avoid delay in having to go back and obtain additional court orders or file additional written stipulations. It is unclear whether the notice which mediators have to send in Rule 1.700A2 must be filed with the court. We respectfully request that this be clarified and proposed 1.700A2 be changed. So we are not required to contain instructions for access to communication technology in court orders, filed written stipulations, or filed notices to protect privacy and mediation confidentiality. We do not believe that information regarding links, passcodes, telephone numbers, or other information regarding electronic communication should be filed in the court file. In conclusion, mediation appearance rules should be consistent for all types of mediation with an emphasis on party self-determination, without a default or preference for in-person appearance. We believe it is important to clarify what types of mediations and arbitrations are governed by the 1.70 rules, and that there be language which permits flexibility in changing the communication process as the need arises if agreed to by the participants. We urge the court to protect the privacy and security of court-connected mediations and non-binding arbitrations using electronic communication by amending the 1.700 notice rule to delete having to put forth the information regarding access to the communication technology. Thank you so much for your time.
Thank you.
I don't know if you have any questions of me.
Thank you. Mr. Apt.
Thank you, Chief Justice. May it please the court. I'm Alan Apt. I am the chair of the Criminal Procedure Rules Committee. I'm here in support of the work groups 3.116, 3.130, 3.160, 3.180, 3.191, 3.220, and 3.851 suggested revisions to those rules. Our committee, if the court does not know, the committee is broken down into basically one-third, 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 prosecutors, defense attorneys, and judges. And our committee generally has spirited debates on all of the proposed rules. Specifically, the committee addressed an addition to 3.116, which would be a requirement for non-evidentiary hearings to have remote technology to be used. The work group declined to adopt or to suggest that that be included in their amended rules, and suggested that it be done in a reform of a referral to my committee. And when my committee receives such referral, we would take it up if that's what the justices decide in their opinion. And I've yielded most of my time to the criminal law section, and I'll be available for any questions for the court.
Thank you, Mr. Apt.
Yep.
All right, now we come back away from the
Live and
screen.
in
Mr. Blank.
Good morning, Mr. Chief Justice, and may it please the court. Jason Blank. I am chair of the Florida Bar's Criminal Law Section. I'm treasurer of the Florida Association of Criminal Defense Lawyers and a member of the Criminal Procedure Rules Committee. And today I argue on behalf of all three. During the course of this pandemic and through the various waves and variants that we have seen, this court, by way of the Chief Justice, has administered multiple administrative orders to the trial courts of this state, dictating to them or advising them that they were to favor the use of remote technology in the criminal courts for non-evidentiary proceedings. Despite those orders and the further guidance that was given by the
Could you
Chief
slow
Justice-
down a little bit for me, Mr.
Yes,
Blank?
I'd be happy to. With only 4 minutes,
appreciate
I'm trying to get it all.
I know.
But I will, Justice.
I will be generous. with
Thank
the
you.
time.
Despite the administrative orders by the Chief Justice, what we have seen throughout the state of Florida is that there are judges who are dispensing with the use of this remote technology for these types of non-evidentiary, non-essential proceedings. We are seeing that the use of Zoom or GoToMeetings or Google Hangouts, as the various circuits may use, are no longer being used, and the courts are ordering the lawyers and the litigants to be present before them for all matters, ministerial or non. That is why this court should adopt the proposed amendment set forth by the Criminal Procedure Rules Committee and the Criminal Law Section, which differs from the work group's proposal in that it mandates that when a request is made by one of the lawyers before a court for non-evidentiary hearings, that the court should and really must grant that request unless good cause is shown.
Why are we in a better world if we've taken away that discretion from judges?
The key here is that these types of remote proceedings and allowing the litigants to litigate their case in a fashion that they see fit by appearing remotely, much as Judge Munyon noted, if the lawyers wish to be represented remotely, why should they not? It is a more efficient, more effective, and more just system to allow.
So then why wouldn't you be able to persuade a judge to exercise his or her discretion that way?
And the idea behind the proposal by the Criminal Procedure Rules Committee is that the request or the motion, should it be such, to Justice Grosshand's earlier question, would be the initial persuasion. However, it would be incumbent on the court to find good cause not to. What we are seeing is that there are some judges who just don't like change. Some judges just don't like change. They don't necessarily want to use this remote technology. Maybe they're not comfortable with it. Maybe they just like to have the social aspect of having the lawyers before them, and that's certainly understandable. But nonetheless, we are
fairness,
in a...
Counsel,
yes.
in fairness, at least I've been hearing a lot of behavioral problems of lawyers appearing on Zoom, dress problems, addressing the court improperly. There seems to be this attitude that all formality of the court proceedings are just out the window. So how do you answer that?
Yeah, I would argue to that, Justice Labarga, that while there may be certain instances where decorum or discretion of the lawyer may not be where it should be, and that may be an issue, that is not seen in the majority of remote appearances before the trial.
That also
courts.
happens in court, doesn't it?
And it does also happen in court, yes, Mr. Chief Justice. And I would also argue, Justice Labarga, that at any point in time, a judge can say, I'm ordering you before me at 9 a.m. tomorrow, be here with your client. Just like at any point in time, a judge can say, I find it good cause that you appear before me because I've seen you wearing shorts on Zoom, and I don't believe that to be appropriate decorum. The good cause provision in the proposal by the Criminal Procedure Rules Committee and as suggested by the Criminal Law Section allows for the court to still have discretion to order the lawyers and or the litigants before it at any given time. The main concerns, I see my time running out, so I'll conclude.
I'll give you a little more time.
Thank you so much, Mr. Chief Justice. The main concerns of the work group, and candidly of the minority position of the Criminal Procedure Rules Committee to some extent in their opposition to the proposal. In the Criminal Procedure Rules Committee, the minority said, well, we believe, and this really came from the judges, saying we believe that the appearance of the lawyers before us on the final pretrial conference before trial setting is important to hash out any remaining motions, any remaining issues, and possibly even resolve the case. We certainly, and I say we because I was a member of the majority on the Criminal Procedure Rules Committee that voted, we certainly understand that, and that is why we have the good cause provision, or the good cause safety valve, if you will, in the proposal. Were a trial court to feel that it be necessary that that final pretrial conference be held in person for those reasons, our position is that would constitute good cause. The work group's other objections to the proposal, really to take the language set forth by Justice Lawson earlier, are not legitimate concerns. The reason why is that the work group, and let me be very clear here, I appreciate the work of the work group. It's a very large undertaking that Judge Munyon had in her group, and they did a great job. But in responding to the amendments suggested by the Criminal Procedure Rules Committee, the objection was based on the fact that sometimes these non-evidentiary hearings somehow magically convert into an evidentiary hearing. Candidly, that's a fallacy. I can think of no time when a matter set and noticed as a status hearing magically turned into an evidentiary hearing and a court allowed it to go forward. More likely, and really what mostly happens in the courts around the state, the judge says, counsel, this is not what this is noticed for. Call my JA and get a hearing on special set calendar, or or show up tomorrow at 9 a.m. with the litigants or with your clients and the witnesses, and we'll address it then. So to the extent that that is the objection of the work group to the adoption of the Criminal Procedure Rules Committee proposal, I would argue it should not be given weight. Lastly, the work group suggests that this should be, and I apologize if I'm going fast, Justice Lawson, I'm trying to finish up here. Lastly, the work group suggests that this should be sent back to the Criminal Procedure Rules Committee to be considered, and that's based on the secondary carve-out that was set forth by the Rules of General Practice and Judicial Administration proposal to Rule 2.530. However, that's already been done, and to send it back to the Criminal Procedure Rules Committee would be redundant. This has been discussed, vetted, and proposed to both the work group and now the court as an amendment to Rule 3.116, or the proposed Rule 3.116, as a new subsection, and we would urge the court to adopt that subsection for the betterment of the courts in the state. Thank you very much.
Thank you, Mr. Blank. Mr. Morrison.
John Eddie Morrison on behalf of the Florida Public Defender Association. Thank you so much for allowing us to appear here today. Given the work group's amended proposals, we will address only issues 2 and 3 in our written comments. Both of them turn around the same principle, which is that although video hearings are often useful and helpful, a good option, they should never be the only option when liberty is at stake. That is the fundamental heart of this court's decision in Doe. This is how we have done jurisprudence since there has been jurisprudence. And that has not changed with technology, particularly for our mentally ill citizens. I, by sheer coincidence, yesterday was reading through a transcript of a schizophrenic young man who was explaining to a judge in all sincerity that the witnesses in the little boxes on Zoom could have been anybody. He speculated that they were his mother. This is not a problem technology is ever going to solve. This is a situation with our mentally ill clients. They should be the very last people whose liberty should be subjected to curtailment based on a video hearing when they walk into a small room with a desk and a computer and the Hollywood squares of a Zoom meeting. Let's just be honest. Many of these clients have schizophrenia, paranoia, all sorts of mental symptoms of their diseases. Their grasp on reality is often slippery, and it is not helped by, as Justice Labarga suggested, some of these Zoom hearings, they're simply more informal by the sheer nature of the technology, even as we saw this morning in the hybrid part of this proceeding. Technology is just clunky. It doesn't feel the same. It doesn't feel real. And we all know the difference. We all know the difference from, you remember the first time we got to see our relatives in person again after only seeing them in video. There's a difference. It matters, and it's important. We are grateful for the work group's understanding of this principle in Rule 3.116, when the work group amended it to provide that in criminal cases, defendants should always have the right to appear in person before a live judge unless they waive that. And many times it'll be convenient and useful for everybody to waive, but when it's not, when a defendant wants to appear for whatever type of hearing, and often the hearing's important in criminal cases, this court knows very few criminal cases go to trial. Percentage-wise, it's a minor fraction. The important hearings are the motions to dismiss for stand your ground, motions to suppress, the bond hearings. And the defendants always have the right under the work group's amended proposal. We appreciate that. We believe that is the correct principle, and we believe that that should be applied both in the criminal cases and in the Baker Act Marchment proceedings. Those are my comments. I'll take any questions from the court, in which case I will cede my 24 seconds to the Florida Disability Rights.
Good morning, Mr. Chief Justice, and may it please the court. I'm Caitlin Clibben with Disability Rights Florida.
Could you speak up just a little bit?
Yes.
Thank you.
Do my best. I'm Caitlin Clibben with Disability Rights Florida. Disability Rights Florida is the designated voice for those with mental illness in Florida and has a long-standing interest in making sure that the proceedings relating to the Baker Act are fair and protect the rights of those individuals with mental illness. Disability Rights Florida urges this court not to adopt the changes to Rule 2.530 as they relate to Baker Act proceedings. We urge you not to overturn Doe and not allow remote Baker Act proceedings at the court's discretion and over objection of the person subject to that hearing. The justifications offered to have remote hearings in Baker Act proceedings ignore the incredible vulnerability of those who are subject to the Baker Act, as my colleague just discussed, those with mental illness, and it ignores the increased scrutiny that is due to them anytime their rights are at stake. In Doe, in 2017, this court gave that careful scrutiny to this question. In Doe, the court considered reports from this court's own subcommittees and work groups, from the Department of Children and Families, from Baker Act experts, from legal service providers who work with those with mental illness, and a failed pilot program for remote delinquency hearings, children being a similarly vulnerable group. And in Doe, this court balanced all of that evidence against cost and efficiency of technology, and decided that.
Given the state of technology today, do you think it would be possible to put together a Baker Act hearing room on both ends that would provide a better environment for the population that you serve? Because courtrooms can be really intimidating. Some of the rooms that I've seen where Baker Act hearings are happening with all the chaos going on are really not good now. It seems like, given the savings of having judges drive across the county and all the disruption, that we might be able to fund something that on a case-by-case, courtroom-by-courtroom basis, we could come up with something that would even be better than what we have. Do you think that's possible?
I think that's right. And what you said on a case-by-case basis, I think that's the key there. I think that for those, like my colleague just described, who are having severe paranoia delusions, even a very nicely set up courtroom may not be sufficient to allow them to meaningfully engage. It may cause them to honestly just opt out and refuse to appear at all and not have any participation in their hearing. And like you said, I think it's a case-by-case consideration that needs to be made. But courts should not be allowed to, over the objection of that person or their attorney, force them into a remote proceeding when they're saying my mental health will not allow this to go well.
Thank you very much.
So in Doe, this court really carefully considered all the potential impacts to people subject to the Baker Act proceeding. And in this petition here today, that careful, methodical consideration is not reflected. I don't see surveys of mental health experts, surveys of folks who are subject to the Baker Act proceeding or their families to find out if they've experienced negative impacts. We're not seeing, and during the pandemic, because it's still ongoing, there has not been a reasonable basis for attorneys to object to remote proceedings and describe these negative
Counsel,
impacts.
Is there have we ever overturned a constitutional ruling in a rules case? I'm not talking about changing a rule because we decided that the policy and the rule needed to be changed. But have we ever, when there's a due process holding in Doe, have we ever changed a constitutional holding like that through a procedural rule?
Mr. Chief Justice, I am not aware of this court having done that.
Has that been cited anywhere in this proceeding?
No, not that I have seen in any of the materials provided. No evidence for that having happened before. And I know I'm out of time over here. So I will just wrap it up and say that the careful, methodical consideration given in Doe is what's due to people with mental illness, these incredibly vulnerable folks who often are unable to advocate for themselves effectively. And we simply ask that this court recognize that Baker Act proceedings are unique and they're specifically designed by the legislature to protect the rights of the individuals subject to them. They're not just any hearing, and we ask you not to lump them in and not to treat them as just any hearing. Thank you.
Thank you. Judge Munyon.
Thank you, Chief Justice. Unless members of the court have any questions, we would rely on our petition and response.
Could you address the legal aid organization's concern about the opt-out for those who have no internet service?
And Justice Polston, are you talking about opting out of a virtual proceeding?
Yeah, as I understood, his concern was that the default is electronic unless you opt out in some way, and he expressed that that would be difficult for some people who have no internet, as I understood it.
Yes, the opt-out of the email service and using the form. Forms, pro se litigants find the forms that have been instituted by this court pursuant to rules petitions. They're readily available at the courthouse, on the internet, in law libraries, and they find them because we see that they find them. They file them.
It seems like I was trying to picture of the group of people he might be talking about. And I mean, in most places in cities and stuff, I mean, you find the nearest McDonald's, right? And you can go in, or a fast food place. At least in my neck of the woods where I come from, there's no McDonald's. So in very rural areas in the state, which exist, I see those as perhaps the most problematic of having access to internet. So that's the population that I think would perhaps struggle the most in being able to find some type of access. Is there some means for them to easily deal with the situation he was describing?
I believe that they could find the forms at the courthouse, the law library, the library, other places that they might either have internet access or access to actually written materials. But the same issue arises even if you just change the rule. Without some access to the rule book, they're not going to know that the rule changed and that they have to provide their email address as part of the certificate above their or below their signature. So I don't believe that it is a real obstacle to people providing the form to the court.
But what's wrong with what Mr. Musto suggested? Why would that not work? They give the email. Are you afraid that people who actually have email addresses are just going to decide they don't want to play in the email world?
Absolutely. We see that happen now. We see that happen. I think I'm very reticent to give my email address out to many people. They ask for it and say, why do you need it? I'm not going to put my email address in this particular form because I don't want you to send me junk. And I do have concerns that there will be gamesmanship and that it is one thing not to put your email address in your certificate. It's quite another to say under penalty of perjury, I don't have email or I don't have access to internet.
Help me understand the gamesmanship.
Yes.
Okay, so I purposefully declined to provide my email address because I would like this proceeding to happen in person. Right?
No, I don't provide my email address because I don't want to receive court documents or documents from the attorney on the other side or the litigant on the other side via e-service. I want to sort of slow down the proceedings and have that 5-day mail rule applicable to every document in the case.
Kind of an obstructionist tactic.
And it's something that reared its ugly head in the foreclosure crisis. We did see those sorts of games being played at times. Thank you.
May it please the court. Your Honors, I just want to touch briefly on the comments that were raised by Mia Tell regarding the mediation rules. The first comment she made was that she wanted the parties to be able to stipulate midway through the process to change the format of remote technology if that became necessary. as opposed to having to adjourn the proceedings, go back to the court, and get a new order or have an order incorporate a new stipulation. I think the response to that is that, first off, the rule is written as it is to allow the trial court to retain the ultimate authority over how the proceeding will go if it wants to. But absent that sort of control by the trial court, there is nothing that would preclude in this rule the parties from making whatever stipulation they want up front, which can include a stipulation that should it be necessary to change the format of communication technology. If somebody's going to be in a remote location and they may not have reliable internet service, we can switch just to audio technology for that person if the parties agree to that. The next thing she mentioned was that appearance requirements should not have a default in-person requirement. Well, right now, physical appearance is the default requirement unless the parties or the court, unless the parties stipulate or the court orders to the contrary. The work group did not change that. All the work group has done is to memorialize that remote communication technology can be used either in whole or in combination. And then finally, the notice concern, that actually is a legitimate concern if the notice has to be filed with the court, and if the notice that's filed with the court gives away say the password for a Zoom link. There's usually a user ID or a meeting ID and a password. If the mediator is designated to give notice and can give that information in an engagement letter that is not filed with the court, or can provide it in a separate notice in addition to the notice that must be filed with the court, then I think that alleviates the concern. But if notice is construed as an engagement letter, which would put the parties on written notice, that's not filed, and I think those security concerns go away. Thank you very much.
All right, thank you. We thank you all for your participation in today's argument. Again, I want to thank the work group and all the commenters, including those who not participate in the argument, for your participation in this process. We appreciate it very much. The court will now stand in recess for about 10 minutes.
All rise.